Now, this is joint ownership of a husband and wife. Basically, it's called joint tenancy. So, in a typical case of a husband and wife, in the joint bank account, yes, the other spouse would get it. But in that situation, it really only postpones a probate. And there are some other disadvantages. If it's in a trust, you get a complete step up at the time of death for capital gains tax purposes. If it reverts to the other spouse without a trust, there's only a 50% increase in capital gains on the half that belong to the decedent. So from a tax standpoint, it's not good. And from a planning standpoint, it may not be wise either, because if it just reverts to the other spouse, worst case, they both die in a car accident at the same time, and then there's a probate on both estates, husband and wife. Other type of case is that the survivor may remarry and pass that wonderful stock and bond portfolio to their next spouse, and then on to the second spouse's children, instead of benefiting the children of the first marriage. So those are the disadvantages of joint ownership, among some others.
Thank you.
So the question is, if somebody dies and real estate joint tenancy property goes to the other joint tenant, is it going to increase? And of course this gets into a technical question. Was it your primary residence, etc.? That's one question, if it's primary residence. The other one is between parents and children, or husbands and wives, it should be exempt from a tax increase. And so there are certain limitations on that, and you have to get consultation on those limitations, but typically between a husband and wife or between parents and children, there's no, it's exempt from a tax increase. Between other family members or non-family members, there would be a tax increase. Okay, step up in basis. Supposing it's a husband and wife. And let's make the numbers easy just for the sake of argument here. We have, say, joint tenants owning $650,000.
A house?
A house.
Okay.
Let's say that as joint tenants, you only get half of the cost basis subtracted. So supposing there was $50,000 cost, only half the cost basis gets subtracted there from the value. Now, if there's no community property, you're only going to get 1/2 of a step up.
So for example, if the joint tenant dies and the survivor is going to sell the property, then their cost basis is $300,000,
right?
Or there approximately. And so when they sell for $650,000, they would they would have to pay a capital gains tax. But each one of us has a $250,000 credit, so we would have to pay a capital gains tax on $50,000 if we had it in joint tenancy. What if we had it in community property with right of survivorship?
In community property, 100% of that $650,000 is stepped up. So it's stepped up from the $50,000 basis up to the $650,000.
So there's no tax when you sell. It is really, and it works with stock, houses, everything that you own. You get a step up in basis. It's one of the major benefits as far as taxes is concerned. The step up in basis rule. So when people put their children on title, the children get your cost basis. Not a good idea. Is another good reason not to use joint tenancy to pass assets on, because it's a killer from a point of view of income taxes.
In addition, if you transfer it to the children, depending upon what year it is and what the value is, you may be subject to gift tax on the part of the children. You may be making a taxable gift. So if it's more than $13,000 per person, it would come out of your lifetime exemption. And of course, if you're somebody lucky enough to have some multi-million-dollar property, say in Newport Beach, then it may become subject to gift taxes.
What's your lifetime exemption amount this year?
This year, $5 million.
$5 million. And how long is that $5 million lifetime exemption going to be good for in the law today?
That's good until December 31, 2012, and we don't know what happens after that. It's up for grabs. It may go back. If they don't change the law on January 1st, 2013, it goes back to $1 million per person and a tax of 55% on anything over the first $1 million.
And what would be, as a renowned attorney in this area, what would be your prediction as to what will happen?
My crystal ball is broken. I can't predict anything that will happen in Washington, D.C. right now, because until, the last few minutes on Friday night, we're all wondering, did it shut down or did it not? Is the mail going to go out Saturday? Blah, blah, blah. And I work with a charity, and they were actually scrambling on Wednesday because they get funding with local cities and governments, and they needed to get reports in so that if it shut down, they would have all their reports in the computer. So, basic point of this, we don't know what the government is going to do. Joint tenancy means that anybody either on title for real property or for any bank or savings or investment account is also subject to creditors and bankruptcy and creditors of the other person who's put on as a joint tenant. So say you put your son on your home because you think that'll make it easier for him when you pass away, and he won't have to go through the probate court process. Unfortunately, your son gets sued. Whoever has the judgment against your son can apply that to your home because his name is on as a joint tenant.
Talk a little bit about beneficiary designations.
The other way that you can arrange assets to transfer without a probate, of course, is beneficiary designations of a life insurance policy, an IRA or 401k, and you can even do it with bank accounts. The problem with all of that is that they are not controlled by your will, they are not controlled by your trust. So some people make these beautiful documents, and I've seen my clients do it. They'll set up either a will or a trust, and they'll say who's going to get what percent, and this daughter's going to get this, and that son is going to get that. And they go ahead and name a beneficiary of their bank account at the bank, and they name a different beneficiary of their life insurance, and they name a different beneficiary of their IRA or 401k. And none of that works together with their trust or will. Once they designate a beneficiary, it will pass by operation of law. And if it wasn't for the son or the daughter that they wanted to benefit, somebody else, maybe even an ex-spouse, is going to get those assets.
So it's really important to understand and know your beneficiary designations. And we're going to spend an entire session on just the consequences of having these beneficiary designations on your IRA, 401k, pension plans, annuities, because they operate completely different. And many of them don't have a step up in basis rule. Okay? So the person doesn't get that full amount that's in that account. But we're going to spend a lot of time in this area, and it's a complicated area, and we'll have to force you to stay awake because of a lot of statute and legalese in this area. So, POD, what does that stand for?
Pay on death. That's the bank account where you can simply tell them who you want the beneficiary to be. And if it isn't like the provisions of your trust and will that say 50% to my daughter and 50% to my son, sometimes people name just one daughter when the son thought he was going to get 50%. And sometimes if that happens, those families never speak to each other again. If you name a POD at the bank, your trust or your will have no control over that account.
Real story. Hollywood producer divorces his wife, gets a new girlfriend, goes to the attorney, leaves his entire estate to the new girlfriend, finds out that the properties are held in joint tenancy with the former wife. Who gets the property? The former wife. Joint tenancy, PODs, control, operation of law. So you have to know how you have title to your assets. And many of us forget. So get a copy.
Question, why would the bank make you do a POD when you already had a trust or a will? You need to get a specific letter from your attorney telling them how you want to have that bank account designated and to make title in the name of your trust if you actually have a trust. And so that's the crucial issue about trusts that we're going to cover. They have to be fully funded in order to be effective.
Remember, a lot of banks don't know the law, and so they go by policy. And if you go to another bank, they'll have a different policy, but you shouldn't be required to do both. Okay? Just like, hey, where do we all learn how to hold title to real property? From our real estate agent. They're not qualified. They don't understand all this stuff, you know, about step up and everything else.
So if it's in the trust, I should take it out of the POD?
Yes.
Correct. Absolutely. A lot of tellers just don't know, and you shouldn't expect them to know.
So the key point here is don't let those professionals you work with tell you how to take title to your house, how to designate your accounts, or how to designate the beneficiary of your accounts if you have a trust and a will. They should be coordinated with the trust or the will, and you should be getting legal counsel from your attorney on that issue.
Is living trust a way to hold title to assets?
Yes, a living trust is a way to hold title to assets. And so again, the benefit here is that a living trust is not public, and it can be administered very quickly once somebody passes away compared to how long the probate. So the living trust sets up title. And the reason that the living trust is so easy to administer is because title carries on after you die. People don't understand that the reason that a will does not carry title on and has to go through probate is because you're gone. But if you set up a trust, you name the trustee who is going to hold title for the benefit of your beneficiaries, and that person can carry on and doesn't have to go to court to get permission.
So just to review, probate avoiders, living trust, if you have an amount under $100,000 just in your name, $20,000 for real estate, joint tenancy, community property, beneficiary designations, POD, insurance, your IRAs. Those are all probate avoiders.